Joining us now is criminal defense attorney Jonna Spilbor. Jonna, so they had the weekend to think things through. How do you think the prosecution tries to make its case and sum up its case today after they had a rather rough week last week?
They had a rather rough trial, and I think it's going to be a benefit for the prosecution if they do get some of these lesser charges in front of the jury by way of instruction. So they're definitely going to be pulling for that. I think the other thing that the prosecution has been doing, which to me has been very misleading, but it seems to be one of their key points, and that is to say that, look, Kyle Rittenhouse was the aggressor here because he had no business being in Kenosha in the first place. And that is very misleading because, look, he went there only after the rioters and the looters were there. We have to remember that Kenosha, the streets of Kenosha weren't filled with soccer moms hurling yoga mats in protest of pesticides. Kenosha was on fire. And if the protesters had a right to be there, then so did Kyle Rittenhouse in order to try to combat the destruction that was happening all over the place. So I think the defense really needs to make sure that the jury knows it doesn't negate a self-defense defense just because he was someplace where it might have been dumb to be. And that's a nuance that I hope the defense really imparts to this jury.
Yeah, Jonna, stand by if you would. I want to bring in Jonathan Turley, George Washington University law professor, of course, constitutional attorney. And professor, I mean, you look at this case and you talk about this provocation possible charge. And for me, the question becomes, they're really having a tough time, the prosecution, during this whole case of trying to prove that Kyle Rittenhouse was the aggressor when you had this evidence and you had the witnesses really kind of proving that he was not the aggressor in this case.
Yeah, this was a remarkably bad design for the case. Engineers would call this a catastrophic failure just because they rushed to the indictment a matter of a couple days after the shooting. Then they overcharged with first-degree counts, either because they weren't aware of some of the evidence or they were responding to a public outcry. But at points in the trial, the prosecutors seemed to be learning facts at the same time as the jury. And the prosecutors also tended to get the law wrong on critical facts. One of the most embarrassing moments was when the prosecutor was essentially schooled by this 18-year-old defendant who explained that he couldn't have bought a handgun as opposed to an AR-15. But there's also critical flaws here, in my view. The gun charge, which is the misdemeanor, I think is very much in doubt whether he could be held guilty under that law. And believe it or not, it comes down to a single word of and. He has to be found to have violated two different sections of the Wisconsin Code. One of those is that he was 15 or 16. He was 17. And so there's some major problems here. Even if they get a conviction, they could face a very serious appellate challenge. But the big victory they got in the trial, after the trial, I should say, in the motions hearing, was the provocation instruction, that the judge is going to allow them to argue that Rittenhouse provoked the violence. If the jury believes that, it creates a sort of higher standard for self-defense, including a duty to retreat. That was a major win. I just don't think it's going to work because this case seems in just complete collapse at this point because of the contradictions in the testimony.
Very interesting. Now, joining us now is also former U.S. Attorney and Fox News contributor Andy McCarthy. So I have two questions for you, Andy. The first is how you think that in some ways this is like the Chauvin trial, but not in a very specific other way. And then you understand how Wisconsin has a different way of going about things. So help us understand what we might see this morning that might be different to what we're used to.
Well, the difference, Dana, in procedure, for example, when I tried cases as a prosecutor in federal court in Manhattan, the way the procedure worked is the lawyers would go first in the summations, the government goes first, the defense goes after that, and then the government gets to rebut at the end because they have the burden of proof. And then the judge would give the legal instructions to the jury, and then they'd go off to deliberate. Here, in Wisconsin, the judge will instruct the jury on the law first. And the law is kind of complicated here. As John points out, there are going to be a number of charges, and we were talking this morning about how there are lesser included charges in addition to the ones we've been talking about for a couple of weeks. That's going to take a while, and it's a little bit dense. So the judge will do that first, and then we'll hear from the lawyers. And I think this is one of these cases where there's not a lot of factual dispute about what happened, and a lot comes down to the law. So it's probably a little more important than it usually is. And then the other thing I think is different from the Chauvin trial, which we're not used to homing in on for the last couple of years. If you remember, in the Chauvin trial, which involved the George Floyd killing, we were still under COVID restrictions, so there really weren't spectators in the courtroom. In this trial, it's been much more like what a normal trial was before the early part of 2020. So there've been a lot of people in the courtroom, including some supporters of, some of the people who were testifying for the prosecutors and who participated in the rioting. And I just wonder what the effect of all that is on the jury. You have a situation where the case is very intensely covered. You have cameras in the courtroom. The cameras seem to be moving around the courtroom. There's been a lot more fluidity in the coverage that way than anything I've ever seen in the way of a trial that was covered on television. And you have people who are in the courtroom, looking at the jury, looking at what's going on. You just wonder what kind of effect that will have on them.
Right. Interesting.
Yeah. I want to bring Jonna back in because the conversation here Andy was just touching on, Jonna, is the fact that, the lesser charges here. We don't know. The judge hasn't really spelled those out, and he will do so, of course, during the jury instructions. But is it an indication, in your view, Jonna, that when they talk about lesser charges, that it might be a barometer of how strong the prosecution's case was?
Yeah, I think so. I think the prosecution is well aware that their case in many respects stunk, and that the only way for them to really get a win is if the jury can hang their hat on some of these lesser included. But look, these lesser included offenses aren't a win for the defense by any stretch. He might not be looking at, Kyle Rittenhouse might not be looking at life behind bars, but even with the lesser included, he's going to be looking at anywhere from 10 to 60 years. So that's not something to rejoice over if you're his defense table.
And Jonathan Turley, if I could bring you in, one of the things that was very interesting last week was this idea of self-defense. And the Wisconsin law, how does that play into here? Because as the nation is riveted at looking at this trial, the jurors have to listen to the instructions from the judge, and it's Wisconsin law that they have to pay attention to.
Yeah, the Wisconsin law is actually very generous in terms of self-defense. And so once he puts that into play, which Rittenhouse did, the burden shifts to the prosecution. They have to disprove it. And instead, they seem to go out of their way to prove self-defense, including tremendous blunders, with witnesses. But one of the most damaging parts of the trial was when one of the individuals shot admitted to the defense that Rittenhouse did not shoot him when he had his hands up, and then he fired after this alleged victim pointed a handgun at his face at close quarters. That was just an absolutely catastrophic moment. And so this is a lot for the jury to accept. And lesser charges are commonly considered in these cases. But you can really damage your case by overcharging. The jury, I think, conceptually starts with the most serious offense and works down. If that first-degree charge is wildly out of reach, it can really undermine your case. And the last problem is an opening statement is almost like an oral contract. You are promising the jury to produce something. They promised this jury that they would see a gun-crazed vigilante on basically a bloodlust. And that's not what they got. And that's going to hurt the prosecution.
All right, Jonathan Turley, Jonna, and Andy, thank you so much.
Hi, everyone. I'm Brian Kilmeade. I want you to do me a favor. I want you to click to subscribe to the Fox News YouTube page. This is the only way that I know for sure that you're not going to miss any great commentary, any great news bites, any great interviews coming your way on Fox. You can get it all here on YouTube. So subscribe right now.